When someone passes away, their family must manage their final affairs, a process called estate administration. Probate is the Supreme Court of New South Wales' official recognition that a will is valid. This court order gives the executor, the person named in the will, the legal authority to manage the deceased's assets. Without probate, banks and other institutions won't release or transfer assets. The court checks the will's authenticity and ensures all legal requirements are met. Probate protects beneficiaries and creditors, preventing disputes and fraud. It's a safeguard for transferring wealth and upholding the deceased's wishes. Once granted, the executor can collect assets, pay debts, and distribute the estate as directed in the will. Probate ensures the process is orderly, secure, and legally sound. The executor, named in the will, is responsible for managing the estate. Their first job is to locate the original will and identify all assets and debts. They must notify institutions, create an inventory, and publish a notice of their intention to apply for probate. After a waiting period, the executor submits the application with supporting documents to the court. Once probate is granted, the executor collects assets, pays debts, and manages investments or property as needed. They must keep detailed records and act in the best interests of the beneficiaries. Only after all debts and taxes are paid can the executor distribute the remaining assets. This final distribution fulfills the deceased's wishes and closes the estate. The executor's careful work ensures everything is handled legally and fairly. If someone dies without a valid will called dying intestate, a close relative must apply for letters of administration from the Supreme Court. This appoints an administrator who manages and distributes the estate. The process is similar to probate but can be more complex without a will. If the named executor can't act, a beneficiary may apply for letters of administration with the will annexed. The administrator's duties mirror those of an executor: collect assets, pay debts, and distribute the estate. Without a will, distribution follows a strict legal formula, which may not reflect the deceased's wishes. This highlights the importance of having a valid will. Not every estate needs probate or letters of administration. It depends on the type and value of assets. Jointly owned property and small bank accounts may not require a formal grant. Significant assets like real estate or large bank accounts almost always do. Applying for probate or administration can be complex and stressful, especially during grief. A lawyer can guide you through the process, ensuring everything is done correctly and efficiently. For expert help in New South Wales, consider consulting a specialist like Michaela Money at MJM Lawyers. Disclaimer: this video is for general guidance only. Always seek professional legal advice for your situation.